Hello friends, welcome back. In this video lesson, we shall be talking about nomination. Nomination is part of your estate planning. In other words, it is part of the process of anticipating and arranging during your own lifetime for the management and disposal of your estate in the event of your death. You should not neglect this important act. You must make a nomination as well as make a will. Now here is the definition of nomination. It is a process by which you appoint someone to receive your assets after death on your behalf. Now let us look at a few more details. A nominee is a person who acts as a trustee on behalf of the rightful legal heirs who will ultimately inherit the property. The transfer of ownership does not happen because of the instrument of nomination. Thirdly, a nominee becomes a provisional member of the society, and he is made a provisional member in order to fulfill the duties of the member who has just passed away or died. Now here are the references with regard to nomination. You will find them in part 7th G of the bylaws, in particular bylaws 32 to 37. There is also a form which is to be filled up in a particular format, which is known as Appendix 14. And the latest amendments of 2019 to the MCS Act, Section 154B-1, bracket 18, bracket C, also defines what a provisional member is and what are the limitations and duties of a provisional member. We made a mention of provisional member earlier. A provisional member is a person who is admitted as a member temporarily after the death of a member on the basis of the nomination form. And this is the status of the person admitted so till the admission of the legal heirs or legal heir as members of the society in place of the deceased member. This is how it has been described in the MCS Act. Now here is a brief summary of the procedure of how the nomination form is handled. First of all, the member will submit form which is shown in Appendix 14 in triplicate. Essentially, the form will have the names of the nominee or the nominees, their address and relationship, and the percentage of share that the person wishes to nominate for each nominee. And in case the nominee happens to be a minor, then the date of birth will have to be mentioned. As we saw earlier, the form of Appendix 14 for nomination is submitted in triplicate. And the reason for that is one copy is kept by the society for its permanent records. The second copy is an acknowledgement to the member that the form has been submitted. You should take care that you submit this form to an office bearer of the society and take their signature that you have submitted it to them. Subsequently, this form will be processed by the managing committee. This process essentially consists of recording the submission of the form in the minutes. And after that has been recorded in the minutes, within 7 days, your nomination has to be noted in the register of the members of society. Having done that, then you will receive an acknowledgement after its record in the minutes mentioning the page number on which the record has been entered. You must follow these steps meticulously so that your estate planning stays in order. You are free to revoke your nomination anytime or make any changes. The first time that you fill in the nomination form, there is no fee. Subsequently, anytime you change or revoke it, which you can do any number of times, you have to pay a revision fees of 100 rupees. Now here is what happens after the death of a member who has completed the nomination form. The society transfers the shares and interest of the deceased member in the capital or property of the society to the nominee or the nominees. And it does so in proportion of the shares and interest which are held by the deceased member. Now here is what happens in case a member dies without nomination, or if no nominee comes forward to stake his claim in 6 months after the death of the member. In such cases, the society invites claims or objections. And in order to do that, they will advertise in 2 local newspapers and also put up a notice on the official notice board of the society. After that, based on the claims which they receive, the managing committee will decide what to do. Once they have determined whom the claim should go to, they will ask that party to fill out an indemnity bond indemnifying their position. In order to understand the procedure fully, please read bylaw number 35. We will now try to get a clearer understanding by studying 3 case studies. In the case study number 1, the question is that a wife is the nominee. The member dies and is survived by the wife and 2 children. The shares, by virtue of the nomination, are transferred to the wife, and the wife thus becomes a provisional member. She retains the status as a provisional member till the heir of the property takes charge. It could be her, or it could be her and the children, or whatever other successors as per the will or the succession law. The question is, can she now make a nomination in the name of her children? Just think about it. Can she make a nomination in the name of her children while she is a provisional member? The answer to the question is no, because you can only nominate if you own the asset. In her status as a provisional member, she is not the owner of the asset. She has only been transferred the membership as a trustee till the designated heirs take over the ownership of the property. Nomination is not about ownership. It's only about the custody of the shares. Ownership transfer will require the execution of the will, or it will be as per the succession law, which is applicable in this case. In case the wife is a successor, only then she can nominate after the process of succession has been completed. Here is case number 2. This is the case of a person who died, was a defaulter. He owed dues to the society which were not cleared, and he was designated as a defaulter. You must remember that arrears and nomination are 2 separate issues. Nomination is about the transfer of the shares to a person who is to keep it as a trustee, and it is the nominee who will then fulfill the duties of the member who is deceased. Society cannot hold up the transfer of shares and the execution of the nomination. Society will proceed as per law for the recovery of dues, which is a separate matter altogether. It has nothing to do with nomination. As a matter of fact, if the nomination is not completed, then who will the society demand the overdue dues? Now here is case number 3, and this is the case where the nominee dies before the flat owner. The husband has nominated his wife as the nominee, but the wife dies first, and the husband has not made a fresh nomination before he died. Now he has 2 sons who approached the society after 6 years, and they want the property to be transferred to one of them. How will this be handled? The solution to this case number 3 is that please refer to bylaws 35, 36 and 37 to understand the process of going about such a case. Also, remember there is no law of limitation on property transfer. We have seen the law of limitation in the case of recovery of dues from a defaulter, and there the limitation was 3 years. But remember, when it comes to property transfer or succession, there is no limit or bar of limitation. So friends, that brings me to the end of this video lesson, and here is a summary of the salient points. First of all, we saw how important it was to do estate planning, both nomination as well as a will. The next thing we saw and took a look at definitions and meanings of the various terms that have been used in this video. Third, we saw where to find the bylaws and what are the sections of the Act that apply. Fourthly, we saw the process and also the question of limitation. Finally, we saw 3 case studies in order to understand the law better. So friends, once again, thank you very much for your attention and the interest that you have taken in watching this video lesson. If you have any doubts or questions or you wish to discuss something more, please use the discussion forum and come up with your suggestions, ideas and queries. With that, I thank you and bye-bye till we meet once again in another lesson. Until then, thank you.